Mr. James.
My lady, good morning. I think only one item of housekeeping from me. You should have a call bundle and an authorities bundle. And I hope the message may have got through to the court that I was proposing to take you, if necessary, to Lord Sales's judgment in Packard of this year on interpretive principles and how all of that works. He's done a tour de force on that, so it was well for you to have that.
Before you get into your stride,
Yes.
The observant among you may have noticed that in the Luxembourg case in 2010, a Mr. C. Lewis was counsel for the Information Commissioner. We don't think that Lord Justice Lewis is disqualified, but if anybody thinks that he is, do say so now. Good. Thought not.
We may all rue the day. For the moment, pro tem, no objection. But my lord, no, of course.
Right.
Not the president of split decision.
Yes. My lord, my lady, you will have seen from the skeleton arguments that almost everything that could be said about a relatively short issue of interpretation has already been said in writing. So I propose to be very short, if I may. I'm going to make 6 submissions and go straight in, if that would be acceptable.
Yes, indeed.
The first of them is that the analysis required by and lying at the heart of FOIA, the Freedom of Information Act, involves balancing competing public interests. The public interests in protecting the particular piece of information from disclosure, maintaining the exemption, that's the wording used, which we'll come back to, against the public interests in the disclosure of that piece of information. And the question is whether that balance in relation to the particular piece of information, the single piece of information you're considering, comes down against or for disclosure. And under the scheme of FOIA, that question must be asked and answered, however that is precisely done, I emphasise, in relation to the single piece of information that you're considering. That's the first submission, very basic. Second submission, and to some extent this trespasses on ground that we've discussed during the course of the permission hearing in front of Lord Justice Dingemans. The second submission is that the premise for the debate that is now before you is that the difference between what I'm going to call the aggregating approach and the siloing approach can make a real difference in some cases. You saw by way of illustration of that fact, but no more than that, that from paragraph 25 of the Upper Tribunal decision, from which this is an appeal, paragraph 25 of that, it's in the call bundle, I think I can turn it now, page 38 of the call bundle if you wish. That was evidently, see the final sentence of paragraph 25 in particular perhaps, but that was evidently the view of the Upper Tribunal with all their experience. And indeed, the Upper Tribunal took the view that the fact that aggregating would or might lead to less information being disclosed, in other words, because the public interest cumulatively might give a greater weight to public interest against disclosure on the other side of the scales, because the fact of aggregating would or might lead to less information being disclosed, that was positively prayed in aid by the Upper Tribunal as support for the silo approach on the basis of a supposed parliamentary intention or presumption, as it were, in favour of disclosure. I'll come back to whether that was a correct approach or not, but this is simply illustrating the point that in their view, not merely was it evident that aggregating might lead to different outcomes in different cases as compared to the silo approach, but they thought that was a positive factor against it because it broached or breached, as it were, the liberal approach to FOIA. And the premise in this case was that the difference between those two approaches would or at least might make a difference, given that the first tier tribunal, it appears, did aggregate the public interest in maintaining the Section 27 and 35 exemptions. See, for that purpose, again in the Upper Tribunal's judgment, paragraphs 15 and 16, or a summary of what the FTT...
Upper or first?
Upper. So upper paragraphs 15 and 16 summarising what the FTT did.
Yes.
I hope that's a convenient way of dealing with that. And Mr Montague appealed against that aspect of the FTT's decision, which, as it were, neatly illustrates. It might be thought that he at least concluded that the aggregation did and had made a difference to the outcome of this case. So that's the premise for the debate, that it can make a difference. Point 2. Point 3, if that is so, and it can make a difference, an aggregation therefore can indeed have a significant effect on the disclosure or otherwise of a single piece of information, that prompts, we submit, an obvious and central question about Parliament's intention. Why, it may be asked, would Parliament have intended that the combined effect and the increased weight of the various public interests against disclosure, why would they conclude that that additional weight should be left out of account if it could make a difference, if you add? So if you do 1 + 1 = 2.5, why would Parliament have concluded that you should leave the half out of account? If all the public interest against disclosure of a particular piece of information, when assessed together, tilt the balance against disclosure, same point, why would Parliament have required disclosure? The public interest taken from the various applicable qualified exemption provisions in fact exist on this hypothesis. They all exist. And in fact, in combination, they do lead to a more weighty public interest if they are combined. That's the whole premise of it. And our submission at core in this appeal is that Parliament must have intended a true balance of all the various public interests in relation to the single piece of information. In other words, a balance which places all of that public interest into both sides of the scale. If aggregation leads to greater weight on the against disclosure side, it is, we submit, a distortion of the proper and full assessment of where the public interest balance should be struck to leave that greater weight out of account. And it's plainly significant to the balancing that there are multiple exemptions in play. There's no proper basis, we submit, for discounting the weight of each. If only viewed individually, they do not overtop the interest in disclosure. The public interest remains in play in relation to the same piece of information, and we respectfully submit should be taken into account as part of that statutory question. Even if, when viewed silo, as it were, or individually, they wouldn't overtop. If you put them together and they do, why would you simply ignore that? So the submission is that taking it all into account is not merely an appropriate, but is the only accurate way of striking the balance that Parliament has required to be struck, because it is the only accurate way of assessing the true weight of all of the public interests, or the totality of the public interest, if you prefer, against disclosure. Is this a point which is of significance to the analysis which you have to conduct? My submission is that it is, because it is a very, very powerful point that goes to the purpose of requiring the balance to be struck and the overall scheme of the legislation. Can I invite you briefly to go to PACAR? And I'm going to take it all in one go because there are bits and pieces in PACAR.
As ever, the authority sent in on the morning of the case is the one perhaps the only one that gets cited.
Well,
does it actually tell us anything that we didn't know already? Maybe.
My lord, it probably doesn't, but it's nevertheless a 2023 Supreme Court decision.
We were promised hard copies.
We can certainly provide you with those.
Is it different from the other 2023 Supreme Court case of own?
My lord, it goes a bit further than that. Yes, it does. The Lord Hodge decision in Project for Registration of British Citizens. the Lord Hodge decision obviously remains important because it draws the distinction between the primary approach of focusing on the wording of the legislation in context and draws in paragraphs 29 and 30 that distinction between that primary approach, as it were, and the secondary aids, the kind of explanatory notes and all of that. That's
Well,
really
wait,
significant.
I'm all in favour of being concise, and you always are. But I think you're jumping ahead and referring to a paragraph of another case which Lord Justice Lewis may know by heart, but I don't.
Very well.
Let's start
with paragraph 10 with Lord
Yes.
Hodge, shall we?
Yes.
The key paragraphs for present purposes, and the only paragraphs I invite you to read for present purposes, are paragraphs 29 and 30 behind tab 10. Tab 10, page 213, using the bundle numbering,
Yes.
paragraphs 29 and 30, which I hope I've just fairly summarised, but could I invite you to read those? My lady have it, tab 10,
I do now, yes. I'm sorry, my bundle is,
they are falling apart.
well, it's very difficult to actually turn the pages in it because the clips are just wonky. Paris 29 and 30.
Paragraphs 29 and 30, please,
Thank you,
my lady,
sorry.
yeah. Page 213 on the bundle numbering.
Yes.
You'll see the primary approach in 29, the references to explanatory notes. I said I was going to take this all in one go, as it were, but you'll
Yes.
see some, I think the Information Commissioner has made reference to explanatory notes, so it's as well to have that passage in mind as well,
Yes.
at paragraph 30. Could you then go, in answer to the question, if it doesn't really add anything to go to PACA, could I invite you to go to PACA, please?
Yes.
And the key passages start at paragraph 40 on page 12, bottom right-hand corner of the report. I'm not sure quite where the report comes from. So you'll see that this was a judgment of the Supreme Court handed down on the last day of or virtually the last day of the summer term, 26th of July 2023. And so paragraph 40, could I invite you to read, sorry, it's quite a long section perhaps, but I think you don't need to trouble with the potency of the term defined at paragraph 48. But if you could read from paragraph 40, that 2 pages, just to the last end of the last 2 lines on the top of page 14, so the end of paragraph 47.
Right.
So, my lord, the reason I take you to that rather long passage is because you have, in this case, a question about how you approach the basic, what's the basic approach to the interpretation of the primary legislation, purpose, literal wording and all of that. That's one theme. I'm going to come back to that in a second. Second theme that at least is potentially relevant here is when can you use and for what purpose explanatory notes.
Yes.
You'll see reference to that.
Yeah.
And the third reason I go here is because, and it's a point of anything against me, but the third reason I go here is because this authority also considers the question when you can consider and when it is legitimate to consider after made secondary legislation as aids to interpretation of earlier made primary. And the relevance of that, I'll come back to it, but is in relation to the EIRs, which were to bring into domestic law in 2004 a European directive of 2003, and therefore after the event.
That's when we're looking at the
EIRs.
Luxembourg case
Exactly
rather
so.
than this case.
Exactly so.
Speaking for myself, I hadn't read, I think I was aware of PACAR, but I hadn't read these paragraphs about subordinate legislation. They seem to me highly controversial, whereas the earlier bits about explanatory notes and so on, I think we've been imbibing with our mother's milk for decades.
You have, but,
Yes.
but the reason let's take them in stages, but the reason I go to the first bit of this,
Yeah.
the very well-known passages which my lord and I have debated in the past, Quintavalle and Lord Bingham and all of that, the reason I go there is to emphasise that it should not be thought, and you'll see the citation from Lord Hodges' judgment in O in paragraph 42, so he was well aware that Lord Hodges produced that, lest it be thought that Lord Hodges' approach in paragraph 29, his primary approach, as it were, in some way cuts out or diminishes the significance of purpose for the purpose of statutory interpretation. This is clear and authoritative Supreme Court guidance that reasserts that to the extent that that's interesting. But it is already within, we respectfully submit, Lord Hodges' analysis. There's no inconsistency there. It's already within Lord Hodges' analysis in paragraph 29, but this just expands it a bit and makes sure that everyone is properly focused on purpose, which it,
The normal way one deals with it is a standard paragraph on the word process. The task is to consider the words read in context, having regard to the statutory purpose,
exactly.
and any admissible any admissible aids to interpretation.
Exactly.
The words read in context, having regard to the purpose, but you've got to look at the words.
My lord, I entirely accept all of that, and the only reason for drawing your attention to this is that the Supreme Court have obviously felt in both of the cases you've now seen a need, as it were, to make assurance doubly sure and set out in a little more detail how that approach works. But we respectfully submit that there's complete consistency between Lord Hodge and Lord Sales's analysis, Lord Hodge in O, and Lord Sales's analysis here about purpose by reference to the well-known passage from Lord Bingham in Quintavalle and Lord Mance, and indeed the earlier authority he cited, Rossendale. So that's the first reason I go to it, because all the points I've just made about how would it work and why on earth wouldn't you take into account the totality of the weight of the public interest is an important point when you're considering what the likely intention is of Parliament in relation to the words used in context. And you will see also on that same theme, paragraph 43, Lord Sales's analysis of what avoiding absurdity means. Effectively, it's a broad church is the theme of paragraph 43, and it's a broad church because it is if you end up with something which is impracticable, inconvenient, anomalous, illogical, futile, or pointless, or artificial, or productive of disproportionate counter mischief, to take the language used in the middle of paragraph 43, that falls within the rubric of absurd, and you can take it into account as part of your purposes of analysis. So for present purposes, and for the purpose of this third submission, that's what I take from PACAR. But I've shown you the other bits, which I'll come back to when we get further on.
Right.
So I apologise, it was produced late. It was, as it were, it was produced in July 2023, so it is relatively recent, but
Yeah.
I hope it doesn't say anything that's terribly controversial, just expounds on reasoning. So, just by way of responsive point in relation to this third submission, we do not accept, respectfully, the Commissioner's suggestion that there might at least be a question over whether aggregation is either necessary or workable. That approach from the Commissioner appears to be that some of the exemption provisions overlap very closely, so you might not need to aggregate. Well, so be it. That may well be true, particularly in relation to some of the sub-provisions, if I can call them that, e.g. the different bits of section 35(1). But, says the Commissioner, others are very distinct, and then, as it were, it's impossible or difficult to aggregate because you might be doing an apples and pears analysis, seems to be the suggestion. We respectfully answer that by saying and submitting that the concept of the public interest, in this case we're focusing on the public interest against disclosure, inherently lends itself to breadth. The public interest in its assessment is not and cannot be crammed into being an arithmetical science. And once that is understood, it becomes that this question is really a point for us rather than against us. These are evaluative judgments that can perfectly well answer the question whether distinct additional considerations might tip the overall balance. And they can all be considered and evaluated together. There is no difficulty in doing that. There's no difficulty in adding, say, foreign policy considerations with domestic policy considerations to see if they overall produce a weightier case. It's what happens all the time. If one was doing a PII analysis, for example, and you were considering the public interest against disclosure of the information for the purpose, that you would add it all together. You would take the public interest in its totality and you would weigh that in that context against the relative importance of the piece of information for determining justly and fairly and properly the issue which confronted the court. But you would weigh the totality of the information, including all its elements, and if they aggregate, in aggregate, they added up to something weightier than their individual parts, you would plainly put that into the scale. There's nothing difficult about that. And likewise, in relation to the point that slightly separate point that Mr Montague appears to be making about this, which is to say, well, there might be a risk of double counting. But again, there's nothing in that. It's not difficult for decision makers, i.e. here, the public authorities, followed by the ICO, followed by the tribunals, followed ultimately by this court and above. It's not difficult for the decision maker to avoid that. You simply identify the considerations relevant to the engaged exemption provisions and ask yourself how the whole package weighs against the public interest in disclosure. To suggest that can't be done, or that there's a danger that you can't deal with of double counting, we simply do not accept that. There's no difficulty, therefore, we submit in weighing everything that properly bears on the public interest against disclosure. And indeed, we do note that on no one's analysis is it said that it's impossible or unworkable or unprincipled for precisely that to happen. Everything that tells in favour of disclosure going into the scales, so that if there are different elements that will feed into the disclosure and the public interest in disclosure, then, and if they together in aggregate amount to more than the sum of their parts, then that sits on that side of the scales entirely properly. No one suggests the contrary. So you would end up with imbalance in terms of approach, is the short point in relation to that. That's the third submission we make. The fourth submission is really a question of approach to FOIA and how you approach generally the interpretation of FOIA. And if I can put it negatively, we do not accept the idea, relied upon it appears by the Upper Tribunal and by the respondents in this case, that FOIA is to be interpreted against, or with a presumption or a leaning against, anything that might tend to less rather than more disclosure. I don't want to be over technical about this, but there is no such presumption, that's the right legal analogy, there's no such presumption built into the Act. And indeed, we submit that that would be an illegitimate approach in relation to the exercise that you are considering, which is how ultimately to interpret section 2.2 sub B of FOIA. The scheme of the legislation, let it be noted, sets out the required analysis, balancing the various public interests. That means we submit accurately doing so, and not doing so in a way that actively distorts the weight that in fact exists against disclosure, where multiple aspects of the public interest are engaged. And indeed, we do note that already in relation to that provision, i.e. the central provision you're looking at, 2.2b, there is already built into the wording of that provision a tilt in favour of disclosure. You'll remember the word outweighs, and that has been taken in the case law, and we take no issue with it. That has been taken to mean that if the public interests for and against disclosure are evenly balanced, then the material gets disclosed. And I can end up very quickly dancing on the head of a philosophical pin in relation to all of this, but that is the position. And so that factor favouring disclosure is built in, but the critical point is it's built in through the structure of that section and the use of the verb, outweighs. The Information Commissioner, in the skeleton argument that has been produced, makes much of the constitutional importance of FOIA and the related case law about a liberal approach, if I can call it that by way of summary, to the interpretation of terms and concepts within FOIA. And we respectfully submit that there is no problem with that approach in principle, as long as one is cautious about when and how you deploy it. And plainly, if you are in territory in which there are, the issue you're considering is whether the Act applies at all, for example, or the breadth of an absolute exemption, then all well and good. One might be able to place some reliance upon that as a basic concept and approach to the legislation. And so, for example, to pick up 2 or 3 of the cases relied upon by the Commissioner, Kennedy and the Charity Commission, Authorities tab 20, don't invite you to go to it, but that was a case about the parameters of an absolute exemption for court records, section 32 of FOIA. And it may make sense in that context, understandably, to police those parameters strictly, because precisely you're dealing with an absolute exemption, that would be a complete answer, and you're not dealing with a balancing of public interest factors, where very different things may be in play. Likewise, for Dransfield, Authorities tab 17, that was a case about section 14 of FOIA, vexatious requests. And where section 14 is engaged, you don't need to do anything in response to the request. So it's again a complete answer. One can see some play for an inverted commas liberal approach in that context. And the same point applies in relation to BBC and sugar, Authorities tab 7. That was about the extent to which FOIA applied to the BBC at all. So all of those cases provide an understandable context in which legitimately that sort of liberal, as it were, approach to things can have play. All involve the extent to which the legislation applies at all, but we are here dealing with a very different issue and set of issues in which that sort of approach, we submit, has no proper bearing on the issue. It isn't about the reach of FOIA, it's about how you implement the analytical tasks that Parliament has set. the exemptions, the qualified exemption provisions and the balancing in section 22B are all built into the structure of the Act. And in those circumstances, we respectfully submit that there isn't any play for, as it were, coming at those provisions with the same lens at all. You just look at doing and properly and fully doing that which Parliament has told you to do. So the provisions of the Act themselves tell you what the answer is. It's similar to the point that's been made in a variety of different contexts. In the context of FOIA, it was essentially the point that was being made by Lord Hope in Common Services Agency, tab 14 of the authorities, particularly at paragraphs 3 and 4. But you get the same idea, the same basic idea that flows through other pieces of legislation which have constitutional significance, like the various pieces of devolution legislation that my learned friend Mr Montague, I'm sure Lord Justice Lewis will be very familiar with, where the essential approach is to recognise the constitutional significance of those acts, but that doesn't lead you to a particular approach to interpretation. You simply apply the ordinary principles of interpretation without gloss, because Parliament has given you a bespoke and carefully crafted scheme. Exactly the same point applies in relation to section 22B and that basic approach. And as I say, when you're coming at that set of provisions, the critical feature is to accurately and fully and properly do that which Parliament has told you to do, which is to weigh all the public interests and all of the weight that they properly have against the disclosure or otherwise of the particular individual piece of information. So that's our fourth point, the basic approach to section 22B and how that should be done. The fifth point is really a collection of points that go to the various textual indicators in the legislation. And the first point that we make under that, the overarching submission, is going to be that the language of the Act, its natural meaning, and all the other textual indicators are entirely consistent with the approach that I have just indicated, particularly in my third proposition about purpose and aggregation and why that's a good thing rather than a bad thing. But to focus on the language, if you have the language of section 22B before you, it's probably as well to have that before you for this purpose. The Act itself is behind tab 1.
Yeah.
And it will be very familiar, I know, to my lords and my lady, how this Act is basically set up. But the words we're focusing on, in Horsby or otherwise, are in 22B.
Yeah.
And the first phrase I wanted to focus on is in all the circumstances. And the significance of that we submit is that the exercise that Parliament has required to be undertaken is one that specifically and expressly requires all the circumstances of the case to be taken into account and weighed. That is an integral part of the balancing exercise that Parliament has required in 22B. And that, we submit, must include, all the circumstances of the case must and does include the fact that there is more than one qualified exemption provision in play. Fact A, and fact B is it must and does also include the fact that if taken together on the particular facts of the case, and it may not always be so, there is more weight on the against disclosure side of the balance, because there is more than one qualified exemption provision in play. That's the plain and natural meaning of those words. They indicate that everything that affects the two sides of the balance on the particular facts in relation to the particular information sought is to be taken into account. So if you leave out of account either or both of those facts we submit, you are doing the very opposite of what Parliament has required. And as I indicated earlier on the respondents' argument, all of the circumstances are to be included on one side of the balance, in other words, those factors favouring disclosure, with any additional weight that the combination might provide, but not on the other side of the balance, even if, as is the premise for the argument that we are having, the combination is significant. That's what we say about all the circumstances of the case. The relevant words are then public interest in maintaining the exemption. And our submission is that that means all, underlined, the prejudicial consequences of the envisaged disclosure that arise in all the circumstances of the case. And we make three sub-submissions, if I may, in relation to these words, public interest in maintaining the exemption. We submit firstly that the exemption means the exempt status of the information, and it isn't a mere reference forward to a provision of Part 2, as the Upper Tribunal appears to have concluded. There are, of course, as you know, two types of exemption, or two types of provision that confer that exempt status: absolute and non-absolute. And they're both called exempt information in the lead-in words to section 2. That's referring to both absolute and non-absolute, sometimes called qualified exemptions.
Now, you see exempt status, I just did wonder at one stage, I don't know whether it's right or wrong, whether it means, particularly having regard to the opening words of T2, interest in maintaining the exemption, that is the interest in maintaining the exemption of the information from disclosure.
Yes. Yes.
Well, what do you've passed over, I don't know whether you were going to come back to it. The first line, exempt information by virtue of any provision of Part 2.
Yes. Well, that refers to both types of absolute and non-absolute
Yes.
in Part 2.
But I think it's said against you, isn't it, that the singular is significant.
It is, and I'll come to that, but
Yeah.
I respectfully submit that it isn't. But there's a prior question, which is what exempt means. What does the exemption means in 2.2b? What does that phrase mean? And we submit that it means the exempt status, or as my Lord or Justice Lewis has put it, the
What I said, one possible interpretation was maintaining the exemption of the information
from disclosure. Yeah.
Was one way you
Yes.
could be. I'm not saying it's right or wrong.
No. But I mean, the reason for this, the base for this debate is rather esoteric, because it's the difference between, as my Lord Justice Bean has just pointed out, it's the difference between it meaning only a particular provision in Part 2 and the qualified exemption provisions, or something broader. Because if it means something broader, then a large part of the singular approach to all of this, which is the Upper Tribunal approach, rather disappears.
That's why you need to read the opening words.
I agree.
What are you dealing with in respect of any information? What type of information? Exempt information.
Exempt from
What do you
disclosure.
mean information which is exempt by virtue of any provision.
And I respectfully particularly agree with that, because those words, which was the point I was making, that those words exempt information in the lead-in apply to both types.
So
They
rather than by
apply to
virtue
both
of
the
any
absolute
provision,
and the
where
qualified.
something is exempt because the provision of the Act provides it's exempt.
Yeah.
And then you look at what B means and you're working out whether the exemption is referring back to the particular provision or the exemption of the information.
Yeah.
Well, that indeed is the question.
That is the
Yes.
question. I agree.
Yes.
But you have my submission.
Yes.
It's about status or it's about the exemption from disclosure, as it were. It matters not for my purpose. It isn't simply in 22B the reference. And one sees that. It's very important to bear in mind in relation to all these textual indicators, because we come to the use of plural later on in the Act and other bits and pieces, but you need to bear in mind that there are two things which render the information exempt from disclosure, or exempt from the duty to disclose, which is in section 1 of the Act. And they are both absolute and then the qualified exemption provisions. So the absolute exemption is then dealt with in 22A, and you'll note that in 22A, which rather reinforces the points I've been making, I respectfully submit, in 22A the exemption is conferred, conferring absolute exemption. And so 22B means, not be too opaque about it, in relation to all other non-absolute information.
22B cannot apply to anything that's an absolute exemption, and subsection 3 tells you what is meant by absolute exemption.
Yes. Exactly.
So we rule all of those out, and therefore anything which for shorthand we call
Is left.
qualified exemption,
Yes.
you then have the balancing exercise.
Yes, you do. You do. That's exactly how it works, I respectfully submit. So that means that in 22B, in all the circumstances, the public interest in maintaining the exemption, i.e. the status of the information as exempt from disclosure, outweighs the public interest in disclosing the information. And so one can ask the question, I think Mr Montague at some point, I'm not sure whether he still does in his scholarship, but you asked the question, well, why is it the public interest in disclosing the information on the other side, and not the public interest against disclosing the information, but rather they've used the words in maintaining the exemption? Why is that done? Why do you not have a direct correlation? Was the philosophical question posed, to which the answer is because the public interest in disclosure is not framed by reference to any subsequent provision in FOIA, whereas the public interests that are legitimate to take into account on the other side are. And as my lady has pointed out, some of them are absolute, they're identified and everything else is not. But the everything else that is not everything else. It's everything else as defined in the everything else in part 2, if that's not too many everything else's to make sense. So they're the legislative.
There's no balancing exercise for absolute exemption. You're either in it or you're not in it.
Exactly.
It's binary. Once you're in it, that's it. And the balancing only comes at 2B, and the question then in 2B is, what are you balancing?
Exactly. Exactly so. But that explains why they've used the phrase in maintaining the exemption, rather, because they could have said, I suppose, in theory, public interest in not disclosing versus, but that wouldn't make any sense, because the Act has gone on with some care to define legitimate public interest, either by reference to absolute or by reference to qualified. Doesn't make any difference here. They've defined it. So it isn't just at large. When you're dealing with the qualified stuff that's got to be balanced, it's only the qualified stuff as defined by Parliament. And that is why there are lots of debates around whether or not Section 35 is engaged and all of that case law. But that, I respectfully submit, is the proper explanation of those words. And once one gets to that point, is the end of this first submission, it is evident that, to come back to the purpose and why we're having this particular debate, it's evident that there is no support to be derived from that wording or that singularity, as it were, the exemption. There's no support for a silo or singular approach. On the contrary, the exempt status or exempt from the obligation to disclose approach must be based on a global view of the public interest. So that's what we say that particular wording means and why it is cast in that form. We have a second point, which is an alternative set of arguments, and the second sub-submission under the heading, what do the words public interest in maintaining the exemption mean, is that even if it does refer to a provision in part 2, and we respectfully submit it doesn't, but even if it does, and therefore you can say, or you tee up an argument that says, well, it's singular, so isn't that frightfully important? The answer is it isn't, because, as we know from section 6C of the Interpretation Act, the singular includes the plural. The debate here has raged not around whether that is the basic purport of section 6C of the Interpretation Act. We all agree that it is. The question is whether the exception to that applies unless the contrary intention appears, is the lead-in wording. And the question is, does a contrary intention appear? My submission in relation to that, the debating point on this alternative argument, on unless the contrary intention appears, is that if anything, there are very, very powerful factors, which I've already been through in my third submission, in favour of a proper assessment, an accurate assessment of the weight of the totality of the public interest against disclosure in all the circumstances of the case, for the reasons I've already given. And there's nothing in the structure or language to indicate to the contrary, for all the reasons we give in our skeleton for the purpose of this appeal at paragraphs 39 to 44. The Information Commissioner says that the fact that the draftsman sometimes uses exemptions in the plural, but does not do so in section 22B, is a sufficient contrary indication. I'll come back to some of those in a moment, but our answer to that is that that is simply untenable as establishing a contrary indication, given that there are two types of exemption, absolute and the so-called qualified in the Act. And so if they're using the plural in some circumstances, A, that's not very significant anyway, and B, it's almost always explicable, or always explicable on the basis that it's referring to both of those types of exemption. Mr Montague advances a slightly different, and only Mr Montague advances a slightly different point in relation to section 6 of the 1978 Act. He says that there is authority for the proposition that section 6 and this rule or principle of interpretation cannot operate to produce what he describes as a different legal result and is merely there for drafting convenience. And he cites an authority called Floor and Davis, which I'll let him develop. It's in the authorities bundle at tab 5. I think he particularly relies on the passage at page 88. But just to make the submissions in advance so he can see what's coming, the statutory scheme, Mr Montague, so the statutory scheme in Floor and Davis was very particular. It was about taxing certain kinds, putting tax on certain kinds of situation, but not others. And our case is obviously not concerned with a category difference or the category differences of that kind. We're not altering the character of the legislation at all. Our approach would not presuppose some different legislative policy to the one that exists and sits behind FOIA anyway. We simply say all factors should be weighed. And it illustrates a rather broader point by way of answer, which is that the implication of Mr Montague's submission is that section 6 and this interpretive rule only works where the single or plural interchange for which it specifically provides would make no difference to anything. But that can't possibly be right. So we say Floor and Davis is concerned with upending a clear statutory objective through the use of the interpretive rule, which would be illegitimate anyway and which we are not doing. Producing a different legal result cannot mean it would lead to the case being decided differently by the courts. That's the very purpose of the assistance which section 6C is designed to give. That's the second subsubmission, which deals with the alternative case. It says even if it is a reference to singular provisions, as it were, of Part 2 and the qualified exemption provision regime, Section 6 of the Interpretation Act, plural includes the singular and vice versa. There is a third point, perhaps, without wishing to overcomplicate it unduly, and it's an in any event.
Still on under 5.
I'm
This
still
is
under 5.
5
Sorry,
little
should
3.
be A, B, C, perhaps. This is C.
5C. Okay.
And it's not even under that. This is on. This is they're really A, B, and C under public interest in maintaining the exemption. Those are the words I've focused on. I've already done in all the circumstances.
Mhm.
So C, if that's stops the new numbers going haywire, is an in any event point. In any event, in a case with multiple exemption provisions engaged, where the aggregation makes or might make a difference by adding weight if you put them all together, there is, we submit, no significance in focusing on the singular language of the exemption, if that's what the other side are doing, which it appears to be the Upper Tribunal was doing. And that is because each exemption can perfectly contentedly have added to it that additional element. If you want an analogy, the extra pound, the extra bag of sugar can be added to the haversack in relation to each of the individual exemptions. What you can't do is to leave out of account the sugar.
Yes, I'm not sure that cooking has helped me understand that. Actually, can you just run that by me again? So I
Oh
don't
yes,
understand.
the point is this: that even if you adopt an individualised approach,
Yes, you
and
do
your-
it provision by provision.
provision by provision, your territory is the assumption in which the aggregation makes a difference. You can still do the aggregation exercise perfectly contentedly. You just ascribe a bit of additional weight to each of the individualised analyses.
By reason of the words in all the circumstances
Yeah.
of the case.
Exactly.
Yeah.
But what you can't do is to leave it out of account.
No.
So it's a bit of an esoteric debate anyway, because you can
Yeah.
get there philosophically if you want to in any event. That's my bag of sugar to the haversack.
No,
With
I
forgiveness for the cooking, but
I don't do much cooking. Yes.
I certainly don't use a haversack when I cook.
well, I do know.
So you got an extra weight as part of the circumstances that are relevant even to the provision that you're looking at.
Exactly so. I wanted just to pick up, again, it's going to get very complicated now, so we better go to Roman numerals. 4 additional,
Hold on a second, can I just have a moment, please?
yes,
Began by saying it's all very simple. I've got 6
6
points,
points,
or
yeah.
was it 7? And then we're on 5C, little something. Anyway,
well, we are, and the only reason we're there is because I'm trying to respond. You're aware that our skeleton was produced in advance of the other side's skeletons.
yes.
So if I was making the 6 submissions, I wanted to try and produce responsive points. And I did toy with doing it the other way around.
No,
which
no,
would
it's-
satisfy my law more, I
that's-
suspect. Set out our positive case and then
Good
have a lot.
idea. It's just your
I've got to-
classifications of
It's just trying to put the responsive points within the structure of the submission rather than giving you 14 responsive points.
I've written down 5C now, so what am I going to write down next?
You're now going to write down 5, new set of numbering, Roman 1, because I'm going to look at some of the other provisions that have been relied upon as part of the textual analysis. And the overarching submission in relation to all of this is that these are we submit, not points of central significance to the textual analysis and the meaning of the words that Parliament has used in context. And both sides have sought to rely on different bits of the Act to support their cases. And I suspect that both sides, if really put to it, would recognise that you can argue the toss either way in relation to each of them, which makes them, as it were, subsidiary points of importance, which is why I take them at the end of this. The first, Roman 1, other provision I wanted to refer to is, we submit, in our favour, if anything, and that's the points that apply by reference to, by way of example, section 35. And this is the point that says, how far do you go with siloing? And the Information Commission's case appears to be that you go as far as to say, you don't merely silo the individual section, you silo the individual sub-provisions within the section. And we've made the point that that tends rather to absurdity if one takes section 35 as an example. And we've dealt with this, and I'm not going to expand on it because I've said everything I want to say about this in the skeleton. If you take our skeleton up, if you would,
Yes, please.
that's in the core bundle, starts at page 179. Paragraph 27 on page 186 is what we have to say about section 35. But the short point is it becomes a bit absurd to start cutting it too fine, and that is the other side's case. Because you're required to consider, as it were, in isolation, in a siloed way, concepts that really are very difficult sensibly to separate and to do that analysis on. So that's what my point about it. It isn't just section 35 that gets siloed, it's section 35, 1A, B, C and D that we set out in 27 of the skeleton.
Yeah.
Well, I don't want to add anything to that. That's what we've said about section 35. And one
It
can...
applies to other provisions, with section 27.
Exactly.
Relations between the United Kingdom and any other state.
Yeah.
Relations between the United Kingdom and any international organisation.
The
So
A, B, C and D, the same point applies with knobs on in relation
talking
to
to the Americans about what to do about a particular crisis.
Yes.
And in B, you're talking to the Security Council, which you
Yeah.
would say the fact that it's both of those might give a greater weight than if it was one alone.
Exactly. Exactly. So we make the point by reference to section 35, and I was going to expound on it, but my lord is ahead of me. 27 does it in the same way. And one can do it by reference to section 31. Take section 31 as another example of the same point. The logic of the ICO's case is that you must weigh prevention or detection of crime and apprehension of or prosecution of offenders separately, not together. It feels a little odd, if I may put it that way. Anyway, so those are the three provisions that provide you with illustrations of that point, the sub-provisions point, sections 35, 27 and 31. That's Roman 1. Roman 2, another set of provisions, focuses on section 17.
And what's that?
That is, hold on, I'll do it in the S. One. Page 22, thank you. This is the refusal of a request and what needs to happen when you refuse a request. And the reason I'm going here is because the Information Commissioner relies on section 17 to say that the references in section 17(1) B and C, you see that specifies the exemption in question and states if it would not otherwise be apparent why the exemption applies. He says that wording points towards the exemption, meaning singular part 2 provision. But we say that all that requires is that you must specify the absolute or the qualified, and then give specifics as to why it's the absolute or qualified provision applies, which will all involve saying which provision. In other words, you can't just say the information you requested is exempt. You've got to say, well, it's absolutely exempt or not, and why. So it goes to the detail of what you've got to put in, what you put in here. But we respectfully submit that there's no great significance to be attached to section 17(1) B and C, because you've got to understand the exemption in question as referring to both the absolute and the qualified. And when you get to section 17 sub 3, if you're still on page 22, that deals with a public interest balance answer to the requester. And here we say exactly the same analysis that I've just been through in relation to section 2 applies.
If we don't accept that, and we say to ourselves, the concept of absolute and qualified is our gloss on the word, so we look at a request or a claim to information is exempt information, and if we were to come to the conclusion that specifies the exemption means there in 1B, exemption is being used as an alternative way of saying a provision giving rise to an exemption, how then does that not then throw light, as they would say, on section 22B? Because they've used on this analysis exemption to mean provision there. Why didn't they use exemption to mean provision 16, 15 sections earlier?
Well, my lord, my answer to that is that you need to understand 17.1 in the context of it being both absolute and qualified exemption provisions.
Yeah,
It
if
simply-
you understand it and disagree with it, what happens next?
Yeah. Well, my lord, you've still got to do the 2-2 analysis, and you've still got to approach the concepts there in the way that we went through earlier on.
The
It
argument,
doesn't say exemption in question, which is the language of 17.1b, if that comes closer to answering my lord's question. What it does is, as we looked at earlier, it says exempt information and then the exemption in the context of 2.2b.
so they may mean different things in different sections, even though that's
Well,
unusual.
they don't necessarily, you can't put that point against me, I respectfully submit with force, because what has been added is the exemption in question in the particular context of 17.1. And where you're trying to identify and make clear that you need to specify whether it's the absolute or the qualified. So they've added in those words which are absent from 2.2b. And indeed the structure of 2.2 is as I indicated, because it starts with the, which is exempt information and so on.
I thought you might have been submitting something different. I had thought you were about to submit that the purpose of section 17 is different. This is somebody asks for information and they're told, no, you can't have it. And when they say specifies the exemption in question, what they mean is tell the person who's made the request why he or she can't have it. And that's what it really means.
Yeah.
And it's not meant to define the use of the word exemption for all purposes across all sections of the Act.
Well, my lord, if I'm allowed
If you're not submitting that, that's all right.
if I'm allowed to be content with that and to adopt it, I do.
Can a refusal under section 17 say, in our view, the following three non-absolute exemptions apply? We're not sending you 3 letters, notices, we're sending you 1.
Yes. And that happens all the time.
In fact, it's got to happen because if it is more than one, even if you do the silo approach, the person concerned needs to know
Which one it is?
that it's either 3 to be aggregated or 3 silo ones. And in fact, Mr
You've still-
Montague
you've still
won the
got-
appeal on the fact that he didn't know why the 35 one was being advanced.
All of that just illustrates that it can't be a singular reading in 17 either.
No,
It's got to be, the exemption in question has got to be read as meaning any exemption which justifies not giving you the information that you're requesting.
Which goes back to the way my lord was putting it to me, which I
Yeah.
gratefully adopted.
All right,
That's the second one.
yes.
The Information Commissioner then also relies on sections 63 and 64. Section 63, section heading refers to exemptions. In the plural, but that means we submit absolute or qualified, not provisions in part 2. So you note, for example, that in 63(1)(a), that this section spans both the so-called qualified exemption provisions, section 35 and so on, and also the absolute exemptions like section 32 and section 37(1)(a). So the section heading to section 63 doesn't help the Information Commissioner, and the rest of that section is entirely consistent with our analysis. And the same goes, we submit, for section 64. Finally, and the fourth short point in relation to this, Roman 4, the Information Commissioner refers to explanatory notes, and the explanatory notes I've taken you to PACAR paragraph 42, which explains the significance of those, their subordinate importance in terms of the statutory exercise. But my short submission, I'll let my friend Mr Knight develop this if he wishes, but the short submission is that the extract that the Information Commissioner relies upon takes matters no further. It fits perfectly well with some of the exemptions. The absolute exemptions aren't subject to prejudice tests. So that's that. The sixth and final submission or point is this. You are aware, and Lord Justice Lewis is particularly aware, that there are two parallel regimes that are in play here, two closely aligned regimes, and indeed two regimes under domestic law that are set up in pretty much precisely the same way and with the same language. And it's entirely possible, indeed it regularly happens, that the same information request will engage both FOIA and EIRs, and they are designed, as I say, in essentially exactly the same way. Regulation 12(1)(b) of the EIR, and just take it up in tab 3. Page 67. The only difference is the exception rather than the exemption.
So which sort of regulation 12?
12(1)(b).
1B,
Yeah. Do you see that's the exact equivalent in structural and linguistic terms to 22B. So that was the legislative choice that was made as to how to implement Directive 2003. Yet, as all concerned agree, the correct interpretation of that language in the EIR is that aggregation occurs. That was what was being argued about in the Information Commissioner Office of Communications and Information Commissioner case in Luxembourg, ultimately. See tab 6 in the ECJ judgment, paragraphs 22 to 32. And you'll see why they reach that conclusion. You aggregate. And there are, as we've pointed out in our skeleton argument, I don't invite you to go to it, but there are good reasons we submit of principle and pragmatism as to why the two should march hand in hand and marry, not the least of which is that the same language is used. That was a point that was noted by the Upper Tribunal in the Craven case. Again, I don't need you to go back to that. We've given you the reference in the skeleton. It's Craven, paragraph 22 to 23, tab 8, page 157.
Being a strict purist,
Yes.
we can't look at what happened in 2004 by subordinate legislation to implement the legislature of a different legislative body to work out what Parliament meant in 2000. Perhaps what we ought to do is say this is actually what Parliament meant in 2000, and either they got it wrong
Or they got it right.
They got it right, but I mean, you can't really change.
No, my lord, and that's why I took you. I said it was a point against me. That's why I took you to the analysis of Lord Sales on the subordinate legislation and that difficult line of authority as to whether or not things are contemporaneous and in the same parliament and all of those slightly more fluid tests as to when sometimes you can, even if technically it postdates. But we're very alive to that point. It's a little more complicated than just that. It always is. And it's a little more complicated because FOIA, when it was originally enacted, I don't think we have this in the bundle, but when it was originally enacted, section 74 made reference to the prospect of the Secretary of State making regulations to reflect Aarhus.
Oh, yes.
This is in the 1998.
Exactly. Exactly. So that predated the act. So there was a provision to say you can react to our which doesn't fundamentally affect the point necessarily, but there we are. And then in due course, after FOIA, we fully accept, the 2003 directive is made in the EU. And you have that if you want it in the authorities behind tab 40. It repealed an old directive of 1990, see recital 2. That old directive did not have an equivalent of the public interest balance provisions. And so the first time that position of equivalence on the EU stage, if I can put it that way, was reached is in 2003. Parliament then passes the 2004 regs, the EIR regs, but at the same time, it also amends section 39 of the Freedom of Information Act, which you do have in the bundle behind tab 1. Sorry, it's getting very convoluted, but section 39, you will see to reflect the EIR and its exception regime. C39 1A for the fact that you've now got the EIRs, and B 39 1B would be so obliged but for any exemption contained in the regulations. And so the position is that section 39, amended in that way, reflects parliamentary thinking about the framing of at least part of FOIA in the light of the EIRs when it came to amending FOIA itself in 2004. So that's the rather more convoluted position, which if anything, I was about to say rickety bridge, but if anything provides at least some connection back to the more present amendments, as it were, post the EIRs. But as I say, we're not going to hang our hats on the EIRs. We recognise that the whole thing post dates, as it were, but Parliament has taken that into account and dragged it back in and thought about it again when it was amending the primary in relation to section 39. If that.
But what it didn't do is see the need to amend
22B.
22B.
No, it didn't. It didn't. But the question then is the thing that is driving the interpretation of 22B the EIRs, or is it the amendment to section 39? So there is it may just be unduly complicated to seek to grapple with this as a at least a powerful aid to interpretation. But we respectfully submit that the broader point remains. It seems at least tolerably clear that it will be a good idea.
But luckily, we're not legislatures.
You're not
Just
legislators.
for completion, were the environmental information regulations made under only section 2 of the former European Communities Act, or were they also made or made only under section 75?
That I don't know. Can we check?
Do that over lunch. Just, I mean, I can look it up myself, but just so we've got it.
We can find the answer to that, I'm sure. The Information Commissioner says that Ofcom does not establish that aggregation is mandatory under the EIRs, but we respectfully answer that by saying well, it doesn't need to be. We just need to establish that in relation to all exemption provisions, the public interest considers it should be applied. And they're entitled to weigh all of the considerations, including any additional weight derived from viewing the thing cumulatively. The final point I wanted to make in opening is a bit of a footnote, perhaps, and we'll see what Mr Lockley makes of all this, but a bit of a footnote in relation to the attempt in the Montague skeleton argument before you to rely on Hansard. We know that Pepper and Hart applies, and that the courts have got increasingly strict at making sure that it applies. The relevant principles.
Well, before we go to the relevant principles, can I just see what the passage that Mr Knights is seeking to claim aid?
I'll let him develop the case. It may be easier to do that, but the passage in question is behind tab 25 of the authorities bundle.
The submission is at paragraphs 35 to 37 of my scheme.
All right, thank you very much. Let's see. Rules of kind, no less. Well, I think we'll let Mr Knights.
Shall we do that? I just wanted to refer you to one passage in the authorities about the approach if necessary. It probably isn't. See, for that purpose, Lord Hodge in O, tab 10, paragraph 32. Tab 10, paragraph 32 of Lord Hodge in O.
Yes.
And Lord, my lady, those were my submissions in opening.
Questions for Sir James? Thank you, Sir James. Mr Hopkins? Mr Lockley?
My lords, my lady, I've divided up the submissions with Mr Knight since the subject matter in our skeleton
Yes,
is
please.
very similar. You can take it that the Commissioner adopts what Mr Knight will say, and the same, I hope, is true vice versa.
Yes.
That, of course, is to make efficient use of court time, and I want to stress that these are matters of long-standing concern to the Commissioner as independent regulator. And I trust it's clear from the written argument that any positions set out orally today by Mr Knight on behalf of both respondents are also and independently those of the Commissioner. So with that caveat, I propose to address you on the history and purpose of the Act, and in particular the way in which that purpose has been applied in the case law as an aid to construction. I'll address you on the natural meaning of section 2, section 2.2, which of course is at the core of this appeal, and why that does not support aggregation, especially when read in light of the statutory purpose. In the course of those submissions, I will also set out the material, the core submission, on why, for the purposes of the Interpretation Act, we say the contrary intention does appear. I'll then deal with some of the linguistic objections raised by the department, and also the practical objection that the Upper Tribunal cannot possibly have intended that each subsection creating a distinct exemption should be weighed individually, which the Commissioner says is in fact the only principled way in which you can interpret the complexity of the Act. Mr Knight, for his part, will address you on the Interpretation Act 1978 as a discrete topic, and he'll take you through the case law on that. He'll address you on Hansard, if you allow him to do so, on the practical problems that would arise from the appellant's interpretation, and conversely the lack of them arising from the respondent's interpretation. And it falls to Mr Knight to deal with the department's ground 3, whether there should be consistency with the EIR and what was decided and why in the Ofcom case. So I hope I've set that division out accurately, and I hope that's convenient,
Yes.
my lords and ladies.
Thank you very much.
The history and purpose, then, just to remind ourselves why that is an issue, all parties are agreed that either permitting or requiring aggregation would lead overall to less disclosure. It won't make a difference in every case, but it will do so in those cases where there are multiple qualified exemptions engaged, and each on its own is not enough to outweigh the interest in disclosure. So that's the scenario that we're discussing throughout these submissions. And the very first point I make is that it's an unattractive proposition to say that where you can't get home on any individual exemption, you then have to rely on aggregating a number of them to get over the threshold of overtopping, as Sir James put it, the public interest in disclosure.
Why, when you're looking at different facets of the public interest, is it unattractive?
Well, as I'll develop this submission, that there's a careful structure in the Act identifying specific public interests, specific exemptions in the public interests underlying those, and the language of section 22B, contrary of course to what Sir James says, directs you to look at those individually.
Yeah, that's a separate point with respect. You're not answering my question. My question is, why is it unattractive to aggregate? If you're looking at different facets of the public interest, some of which overlap, some of which don't, and you're asking yourself, is it in the public interest that this information should or should not be disclosed, then why, in principle, do you say it is unattractive to aggregate?
Well, my lady, first of all, I don't accept the premise of the question, because I say that's not the test that you are asking. That's not a question you are asking yourself, because nowhere in the Act does it talk about looking at the overall public interest against disclosure, and that's a very deliberate choice. So I don't accept that you are doing that exercise, but I do also say it would be unattractive to allow public authorities to do that exercise, because it leads to a quantity over quality approach, where one would simply crowd in lots of individual exemptions that individually don't carry lots of weight, in order to make a weak case stronger, effectively.
Speaking for myself, I think describing that approach as unattractive begs the question.
Yeah.
I mean, the question is what section 22B means. It may be that in many cases it won't make a difference. Nevertheless, I can see why it was desirable that this point should be brought to us, so it can be resolved. But in cases where it won't make a difference, it doesn't matter. Can you give an example of a case where it might make a difference?
Well, it might make a difference in the present case.
Because
I think that is the premise of why we're here.
yes,
Is that looked at on its own, the section 27 exemptions might not outweigh the public interest in disclosure. Looked at on their own, the section 35, well, looked at individually, as we say should happen, the section 35 exemptions wouldn't outweigh the public interest in disclosure.
Are you coming to Sir James's subsections point that the Commissioner says you've not only got to look at each section of the Act, you've got to look at each subsection?
Absolutely, my lord. I'm just getting started, and I hadn't
Gosh.
intended to start
All
with
right,
the policy
well, okay,
arguments.
yeah, right. Keep going.
I agree that the core issue before the court is what section 22 means. I do want to start by looking at the overall legislative history and purpose, because I say that informs how you read that. And is one of the grounds of appeal before this court,
Yes.
because the Upper Tribunal said at paragraph 24, the language of the Act should, where possible, be construed broadly and liberally in the context of FOIA's statutory purpose. And then at paragraph 25 went on to rely on that statutory purpose as a pointer against reading aggregation into the Act. And the department takes issue with that. It says it led it into error by doing that. And in fact, I'm still unclear whether Sir James accepts that there is any such purpose. His skeleton argument at paragraph 19b denigrates what it calls the supposed parliamentary intention to ensure greater disclosure / openness. And Sir James repeated those words in his oral submissions. At one point he put the liberal approach in the notional inverted commas. Furthermore, Sir James treated you at the outset of his submissions to an exposition of what he said must have been Parliament's intention in passing the Act. And of course, in that, his version of the parliamentary intention suited his case to a T. It was that Parliament must have intended that you take everything into account and perform aggregation. And although he set that out with great authority, he didn't do that by reference to any authority.
Well, are you going to, I mean, the starting point is to work out the purpose of the Act from law, and you don't need help for attractive or unattractive. Parliament has decided, they're elected. If they've done something, they've done it. If you don't like it, there'll be an election eventually. So the key question is to look at the purpose of the Act and to see, firstly, where you get, well, firstly, to tell us what the purpose you say is. Secondly, to show us how that comes into the Act. Or thirdly, to show us preferably binding authority on why that is the purpose.
Indeed, and that's what I'll proceed to do now, my lord.
The greater disclosure doesn't help because prior to the Act there wasn't any right to disclosure. After the Act there will be rights to disclosure much more. But the question that we're dealing with is a very distinct part of that. How much further? How much greater disclosure?
Indeed. And my
All
lord,
right,
I
well,
do want to go-
we've all been firing questions at you like 3 machine guns, and I think we ought to let you make a bit of progress before we start firing again.
I'll be grateful, my lord. So I say the first and most obvious clue to the purpose of the Act is in its titles, both the short title, Freedom of Information Act, and the long title, which you have at page 4 of your authorities bundle, an act to make provision for the disclosure of information held by public authorities. So providing for disclosure is the stated purpose of FOIA. Why would you make provision for disclosure? You have in my skeleton argument a reference to the CSA case at paragraph 15 of my skeleton, noting that FOIA was enacted a manifesto commitment of the incoming Labour government in 1997 in response to concern about lack of openness. And you have the white paper preceding the Act in your authorities bundle. Before we turn that up, I would ask you to open, if you could, my lords and ladies, the Earl Child case. That's authorities tab 10.
Yes.
And if we could go directly to paragraph 67, we looked at the speech of Lord Hodge briefly earlier, but this is the speech of Lady Arden. If I could just ask you to read paragraph 67.
Yeah.
With apologies to my Lord Bean if he absorbed that with his mother's milk, but I just wanted to show you that it's perfectly conventional to look at pre-legislative material, not just for the mischief behind the Act, but for such assistance as is derivable from this knowledge in giving the right purpose of construction to the Act. So with that, if you could turn up the white paper, which is at the final tab, tab 26 of the authorities bundle, starting at page 607.
Yes.
And I don't want to spend a lot of time on this, but if you go forward to the Prime Minister's introduction, or preface rather, we see there the commitment to a comprehensive programme of constitutional reform. We believe it is right to open up government. And the penultimate paragraph on that page, legislate for freedom of information, bringing about more open government, described as a fundamental and vital change in the relationship between government and governed.
Yeah.
Page 611, just for your note, you have more of the same from the Chancellor of the Duchy of Lancaster. And then at page 613, into the white paper proper, paragraph 1.2, the words in bold there.
Before we leave 611, the white paper strikes a proper balance between extending access to information, just extending, and preserving confidentiality when disclosure would be against the public interest. Yeah.
Yes, there's no dispute that the liberal approach is qualified by what I will call a rider,
Yeah.
Which we'll come to. We see that in the CSA quotation. But just for the core purpose of the Act on 613, the purpose of the Act will be to encourage more open and accountable government by establishing a general statutory right of access to official records and information.
Yes.
And everything I've shown you in that white paper is then supported and recited in later authorities,
Yeah.
including the highest authorities. So that the point that FOIA is a constitutional right is in the Kennedy case at paragraph 153. No need to turn it up, but for your note, it's paragraph 471 of the authorities bundle. And in the same case, Lord Carnworth, at paragraph 230, page 495, refers to and relies on the white paper we've just been looking at for the breadth and importance of the FOIA right. As to the purpose behind the Act, you have in my skeleton argument the quotation from Lord Walker in the Sugar case, where it was common ground that FOIA was enacted in order to promote an important public interest in access to information on public bodies.
Yeah.
So in my submission, there isn't really any room for dispute that the primary purpose of FOIA is to promote greater openness. The real question of issue is, of course, how that purpose applies in construing the Act. Again, as a matter of high-level principle, that's not in doubt, because it's been stated by the House of Lords in respect of the Scottish Act in the CSA case at paragraph 4. And that's been confirmed by the Supreme Court in relation to FOIA, the English Act, in the Sugar case. Lord Walker at paragraph 77 and Lord Nance at paragraph 110.
You said you quoted them in your skeleton, so rather
Yes,
than
I don't propose to take you
writing
through those
things down.
foundational
Yes.
quotations. Again, what they say is that because FOIA is an act of constitutional significance, it should be construed in as liberal a manner as possible, but there is a rider to that. That proposition must not be applied too widely. And in effect, of course, Mr. Knight and I rely on the primary proposition, construe it in as liberal a manner as possible, and Sir James relies on the rider. You can't take that proposal too far. So I do want to spend a little bit of time looking at a quartet of cases in which that principle has actually been applied.
Yes.
Those cases are CSA, Sugar, in which Sir James was, if anything, too generous to me in his reading of that case. UCAS, which is an Upper Tribunal case, I'll try to take briefly, and then Dransfield in the Court of Appeal. And what I will seek to show you from those authorities is that in those cases where the rider applies, the qualifying or the limiting part of the overall principle, those are cases about the boundary between FOIA rights and some external source of fundamental rights. So anticipating a little bit, in the CSA case, that's the Data Protection Act rights, privacy rights. In Sugar, it's Article 10 rights.
Hold on, so CSA, it's boundaries with data protection.
Yes. I'll show you this in more detail, my lord, in a moment.
And then Sugar is
It's Article 10.
Article 10, yeah.
But conversely, where the issue is how to interpret some self-contained provision of FOIA, if you like, the liberal interpretation has held sway to extend the scope of FOIA rights. And I say Dransfield is a classic example of that.
And by liberal interpretation, you mean that interpretation of the two which leads to more rather than less information being available.
That's correct, and it either operates directly or indirectly, if you like, to limit the scope of any restriction on those rights. So Section 14 is a good example, vexatiousness. That is obviously a radical curtailment of the requester's rights, and Lady Justice Arden, as I'll show you, says because it's cutting down a constitutional right, a high hurdle has to apply to that notion of vexatiousness. And of course, I will go on to say that what you have in this case is a quintessential FOIA-only, self-contained issue to which you should apply the liberal interpretation and not the rider to that principle. the other thing the authorities do is that they say the principle is not so strong that you should override the natural language. You don't do violence to the natural language of the Act. I absolutely accept that, and I'm not inviting you to do that. On the contrary, we say that our reading of Section 2 is already the natural interpretation, and it's the department that's seeking to do violence to that. So I say that I don't have to rely wholeheartedly on the liberal interpretation. I say the two marry with each other. The natural interpretation leads to taking an exemption by exemption approach, and you can take comfort that is also undergirded by the liberal interpretation. So with that overview, the first case I want to take you to is, and the simplest, is the CSA case. That's at tab 14 of the authority bundle. 287. Paragraph 4 at the bottom of page 289, you have the statement of principle, and it might just be worth the court refreshing its memory on paragraph 4.
Can I just see what the case was actually about?
Yes, of course. Request for information about cancer statistics, and the question arises if there are low numbers of high level of granularity, does that become personal information? And at which point the Data Protection Act rights come into play.
Yeah.
So you see
I've
in
never
paragraph
heard of
4.
barnardisation, but you learn something every day.
I was going to ask whether the term was familiar to my lord's name. I'll give a brief explanation. But we see immediately from paragraph 4, the proposition must not be applied too widely without regard to the way the Act was designed to operate in conjunction with, over the page, the 1998 Act, being the old Data Protection Act. And at paragraph 7 at the bottom of the same page, considering the interplay between the FOIA right to disclosure and the DPA right to privacy, Lord Hope said, in my opinion, there's no presumption in favour of the release of personal data under the general obligation that the 2002 Act, that's the Scottish FOIA, lays down. The reference which that Act makes to provisions of the DPA 1998 must be understood in the light of the legislative purpose of that Act, which was to implement the directive. The guiding principle is the protection of the fundamental rights and freedoms of persons, and particularly their right to privacy with respect to the processing of personal data. So it's very clear in the CSA case that the notion of not applying the liberal approach too widely or without boundaries, what's circumscribing the liberal approach there is the countervailing fundamental privacy rights.
Well, that's because that's what the case was about, isn't it? I notice you glossed over the last sentence of paragraph 4.
The scope and nature of the various exemptions plays a key role within the Act's complex analytical framework.
That is in the context of Lord Hope saying that the liberal approach can't be applied too widely.
Indeed, well, we absolutely don't dissent from the proposition that one gives the exemptions their proper weight. But we say one gives them their proper weight one by one. That's the core of the case.
That's the issue, and I'm not sure that liberal interpretation helps one way or the other. Say that you say if we do it one by one, there'll be more information. If you do it in totality, there'll be less.
Well, and so a liberal interpretation guides you to saying that one would interpret section 2.2 in the way that leads to more disclosure, not less.
Well, it's one thing to say, I think there are lots of cases which say the statute sets out a principle followed by an exemption, and you're trying to construe the exemption, and the burden is on the party putting forward the exemption to, cases very close to the line to show why the exemption applies. But it's much more broad brush to apply that to section 2b, and Lord Hope seems to me to be saying in paragraph 4 that it is a balancing exercise, and there isn't of course the purpose of the Act is to open up and provide more access to information. That's obvious, but Lord Hope seems to be saying you've got to balance the two interests.
Well, the question is whether you balance the interests identified by Parliament for a particular exemption or the overall public interest in non-disclosure. And we say well, we'll come to this when I come to the analysis of section 2 itself. We say it's very telling that Parliament hasn't chosen to use any phrase of that kind and has rather chosen language that focuses the decision maker's attention on the exemption in the singular.
That I understand. That's all to do with interpreting section 2 when you read it. But because I'm obsessive about words, I've got section 1 in front of me, and that is the general access to information. And that says that you can make a request and have the information communicated. And the very next word in subsection 2 is subsection 1 has effect subject to the following provisions. So the very opening right recognises subsection 2 as section 2, and the real question one might be suggested is to work out what section 2 means, rather than to assume section 2 means certain things and then look to see for reasons why section 2 means something more.
My lord, I keep promising that I will come to it, and I will.
We never give you the chance.
No.
Do you want anything more from the CSA case?
I do.
Right.
One brief point where you see the liberal interpretation in action is at paragraph 14. Page 293, and here we do have to tangle with Barnardisation, I'm afraid. That is a process of perturbing the data. 14. So that it doesn't exactly match the picture on the ground and makes it harder to identify individuals from it.
Yes.
And if that is done, it is not then personal data. The agency says, well, hang on, that is not the information that we hold. We hold the information as it exists in our hands, and we are not required by the Act to create different forms of information. And at paragraph 15, Lord Hope says, it seems to me that the position that the agency has adopted to the request in this case is an unduly strict response to what the Act requires. This part of the statutory regime should, as Lord Marnock said, and perhaps in the inner house, be construed in as liberal a manner as possible. It goes on to explain. So what Lord Hope is doing there is, that's a demonstration, I say, of where you have an issue that is internal to FOIA. It's not constrained by any external source of rights. You simply have a question, what does held mean for the purposes of FOIA? And you can take a strict approach to that, or you can take a broader approach. And Lord Hope is saying on an issue like that, you should be guided by the liberal interpretation and take a broad view of what held means so as to further the purposes of the Act. So in my submission, the two different ways in which that principle is applied are neatly illustrated in the CSA case. Well, Osman, I can go at more length through the authorities on how the principle is applied, but I sense you're keen for me to get to the section 2 analysis.
Well, certainly that's the heart of it. But if you need anything more from the Common Services Agency case, then
no, I'm finished on CSA.
Do you want to go on to?
I think I will skip directly to Dransfield.
Yes, right. Where's that?
Tab 16.
Tab 16. And is concerned with section 14 vexatiousness, as I said. Again, that is an issue that's internal to FOIA.
So let's just work out what happened. This man kept asking for things and he wanted the drawings of the bridge.
Yes.
And the local authority said, no, we're not giving you the drawings of the bridge because of 14.1, is that it?
Yes.
Okay.
But that followed a long tail of difficult and abusive correspondence from Mr Dransfield.
Yes.
And so the particular question that arose in this case is how far one could go in looking at that background, because the request in issue was concise and polite.
So when considering section 14, how far could you look at the background of earlier requests?
Yes, that's the precise issue, although the case is also the leading authority on vexatiousness generally and how that should be interpreted. So paragraph 2. You have the statement of general principle that I cited in my skeleton argument. Important constitutional act, and then the indirect effect of that is that a restriction on the right must have constitutional implications, and a restriction should be narrowly construed. The flip side of a broad interpretation, a liberal interpretation of the Act, is that anything restrictive should be narrowly construed. If we jump then straight to the conclusions at paragraph 68 on page 346. Next to letter F,
So page
346.
360.
Paragraph 68. But perhaps if you take a moment to read that paragraph.
I'm really, really sorry, Mr. Lockley. I can't find what you're talking about. Paragraph 68 at
Yes.
page 336.
346.
Oh, 346. I'm so sorry. Age and deafness is not helping. 346. Thank you. So sorry. My apologies. 346. Paragraph 68. Yep, got it now.
And if you could just take a moment to read paragraph 68. The key passages that I draw your attention to next to letter F, Parliament has chosen a strong word, which therefore means the hurdle of satisfying it is a high one that is consistent with the constitutional nature of the right. And then the specific example of illustration of how that works at the end, about the motive of the requester and the relevance of that. If his actions were improperly motivated, it may be the request has no reasonable foundation. This could not be said, however vengeful the requester, if the request was aimed at the disclosure of important information which ought to be made publicly available. And Mr. Cross accepted that proposition, which of course promotes the aims of FOIA. So those aims lead you towards a high threshold for a curtailment of the right, and we see that again at paragraph 72 on page 347.
Yes. Well, vexatious is a strong word.
Yes.
Yes. All right. Well, we've got that case.
bearing, as I say, you should, the need for a liberal interpretation in mind. Bear in mind, I'm meeting here a ground of appeal brought by the department that the Upper Tribunal went wrong in using that liberal interpretation as a pointer to how section 2.2 should be read. And that tour we've just been on shows you in my submission that there is absolutely nothing wrong with using it as a pointer, provided it's not doing violence to the language. Because what we have here is an issue that goes to the core of how FOIA operates, and will lead to more or less disclosure accordingly. So I'll set out our reading of section 2.2 with that in mind.
Yeah.
And then I'll deal with various of the objections raised by the department to our reading, and certainly the ones that I've taken on in the division of labour with Mr Montague. So our reading is, of course, that the public interest balancing analysis must proceed on an exemption by exemption basis, and that gives effect to the natural meaning of the statutory language. And the first point is that Parliament has chosen to use the singular at all points throughout section 2.2. It starts information which is exempt information by virtue of any provision of Part 2. And that singular language is repeated in each of the subsections that follows. Section 1.1b is disapplied if, or to the extent that, the information is exempt information by virtue of a provision conferring absolute exemption, singular, or in all the circumstances of the case, the public interest in maintaining the exemption, singular. And we say the plural isn't implied because that structure requires an exemption by exemption analysis. And there are two reasons why that's the case. The first is the simple point that it contrasts with the use of the plural elsewhere, notably in the title of section 2, but also in the titles of section 63 and 64. I confess I didn't fully follow the points that James was making about that plural encompassing both absolute and qualified exemptions. It's clear that section 2.2 makes provision for each of those sequentially.
Yes.
So one looks at an exemption, one asks oneself, first question, is it absolute or qualified? That's the A question. And the key point is that question only makes sense in terms of one exemption at a time. One can't ask oneself whether two exemptions are absolute or qualified. And this is to come to a point, an objection that my lady Andrews raised in relation to section 17 as it happened. Or would one require two refusal notices? The answer is clearly no. It's not that you can't rely on multiple exemptions, but you simply have to rely on each one at one at a time, because that is how the test is structured in section 2, and also, as I'll show you in a moment, in section 17. So there is...
Let's go back to your headnote of the subsection point. You say it's significant that exemptions plural is used in, but surely that doesn't take you anywhere, does it? I mean, at least section 2 has the two categories, absolute and
yes,
non-absolute. And the word, the plural exemptions would be appropriate, even if you're right.
yes. I certainly don't hang my hat on the titles of the sections. That's purely a preliminary point. But linguistically, looking overall, at the text, exemptions means exemptions plural, and exemption singular means exemption singular. That's all I
But it's not the exemptions,
No.
you see, it's the exemptions in part
Part
two.
two.
It's a shorthand word for saying, because section 1(1)(b) refers to subsection 2, this is just saying the effect of what follows in part 2, isn't it?
well, yes. The
You could
more-
have crossed out the word, the exemptions, and then say effect of part 2.
the weightier point in relation to the title
Mm.
is that exemption means provision of part 2 there. But that's a point I'll come on to. That's a separate issue.
Okay. So
The-
the title uses exemption as a shorthand form for provision.
Yes. But I'll come back to that because the important point about singular versus plural is that section 2.2 sets up a sequential test. Picture it as a flow chart. And the first question is a provision engaged? If that provision is engaged, is it an absolute or a qualified provision? If it's absolute, limit
An
A.
exemption can't be both qualified and absolute, can it?
No.
No. All right. So, how on earth do you get to sequence? You know what sort of information you're dealing with because you're starting ex hypothesi with something which is exempt under the Act. It's prima facie exempt. And the question is, should, notwithstanding that it's exempt, be disclosed? And so, if it is by virtue of a provision of Part 2 absolute, then that's the and it's one of the provisions under Part 2 which is identified in subsection 3. That's the end of the inquiry.
Precisely so, my lady. But that's an inquiry you can only conduct one provision at a time.
But
Because
you're-
you don't need to do anything else because you're not balancing anything else. That is just a binary question. Sorry, you cut across my lady.
No, my lord is exactly right. That's the point I was making.
Right,
Well, indeed, but that's the balancing exercise. But there's a prior question: is it absolute or is it qualified? That's your starting question. Do I go to A or do I go to B?
Well, that's the easy bit. Of course,
Yeah.
you first consider, is it absolute? If there's an absolute exemption, that's the end of it.
Indeed. But my lord,
Anyway.
that question you can only ask yourself one exemption at a time.
Yes, because of the nature of the question that you're asking. Is
Indeed.
it raining or is it not raining? It either is or it is not.
Yes.
You don't have to ask, is it an unpleasant day?
So
It's a binary question.
indeed. So if it's not raining, say that's section A. If it is raining, that's section B. Question: how hard is it raining?
Yes, all right. First,
you like.
first we were on cooking, which seemed to me quite useless.
I bet
Now
it's
we're on
walking
weather,
and
which seems to
cooking,
me
yeah.
pretty useless as well.
Yeah.
You carry on,
But
carry
I-
on, Mr. Left.
I don't disagree with anything you're saying. But what I'm trying to convey is that binary question only makes sense one exemption at a time, so that you are only holding on to a single exemption, as it were, when you get to B, and ask yourself the public interest balancing exercise, and that is then reflected in the language of maintaining the exemption. It's the exemption that you have been feeding through this sequential decision-making process by asking yourself first, is it engaged? Is it absolute? If no, go to B.
But the point is that if it's an absolute exemption, it doesn't matter if it's an absolute exemption because it falls both under section 21 and section 23, or whether it only falls under section 21. So you never get into the question of aggregating factors for the reasons why it's absolute. It's enough that it falls under any one of them.
Well, indeed, my lady, but any one of them is the point.
But that's in the nature. The point is that is in the nature of an absolute exemption. If it's absolute, and you're never going to get into a question of whether it should be aggregated or not. So I don't see how the provision in relation to absolute exemption helps your structural point at all, or your interpretation point.
I'll try one more time, my lady. Again, I don't disagree with your analysis at all, other than that the exemption is one or other of those provisions.
Yes.
We say it's not exemption as an overall status of the information. That's the end point of the analysis that you're trying to determine. Is the duty disapplied? I am applying section 2 to a piece of information in order to work out the answer to that question. So you don't start from exemption, you don't start from disapplication of duty. You start from whether a specific exemption is engaged. First question, is that exemption an absolute one or not?
You have to look at the opening words of 2. You're not actually dealing with an exemption at all. You're dealing with in respect of any information. What type of information? Exempt information. Why is it exempt information? Because any provision of Part 2 applies. So you're dealing with exempt information. Then you go to A, it says, if the information is exempt by virtue of a specified provision, which we now call absolute exemption,
Yes.
that's the end of the question.
Yes.
So the next stage then, if you're not into that exercise, because it's not one of those provisions, but it is exempt information, what does B require? And I don't see how anything in A will help you answer that question, because you've got exempt information by virtue of provisions which carry absolute exemption. And the question that we're asking is, when it's exempt information by virtue of provisions, or a provision which is not one giving rise to absolute exemption, how then does that fit into B? And the sequencing doesn't seem to suggest that it's got to be the same exercise as under A.
But my lord, the point I'm making is that the whole sequence that you have just described, and which I agree with entirely, is a sequence which you perform on one provision of Part 2 at a time, because it doesn't make sense to apply.
Exempt information by virtue of any provision. It could be more than one. It's exempt information by virtue of any provision. It could be exempt information by virtue of 1, 2, 3, or 4, and it'd be exempt information by virtue of any provision. One of the 4 I've just mentioned. That's the difficulty.
Well, my lord, you have my submission.
Your submissions anyway, yeah. The sequencing, you say, dictates that it's exemption, by provision by provision.
Yes.
That is provision by provision for A and B.
Yes, and you might, obviously you would stop at A in the case of an absolute exemption.
So, provision by provision for A, and if not A, then B.
Yes.
Thank you very much.
And of course I don't say that means you can only consider one exemption full stop. No one is suggesting that. And that, as will come to, is the answer to the concerns raised during the course of Mr. Eadie's, Sir James's submissions about Section 17. I'm not suggesting that one can only ever look at one exemption. I hope that is clear.
All submission is one at a time.
One at a time, indeed.
Yes.
And to the extent that Section 6 has effect to pluralise the exercise, it's only to that extent that you can do it several times, but you have to do it one at a time each time. And because I say that the exercise would never get you to considering multiple exemptions together, what the department is proposing is in effect an additional stage to the analysis. This is a point from Mr. Knight's skeleton, which I gratefully adopt. You're adding a further stage to the analysis of saying, if I haven't got home on any one exemption, I can then add the public interests together.
Yes.
We say that's no part of the statutory scheme. The department's objection, the first objection, is that is a distorting analysis. And that the Upper Tribunal was led into it by misapplication of the purpose of FOIA. in my submission, that puts the matter back to front. The purposive approach is guiding you towards the open interpretation in any matters of genuine doubt, but where the natural meaning of the words is capable of being the more liberal interpretation, which I say it certainly is here, then you should favour that interpretation. It's only distorting. To say it's distorting is assuming what needs to be proven. And in my submission, the reasons advanced by the department for saying it's distorting are insubstantial. It said that the true weight will not be given to the public interests against disclosure unless they're weighed together. And that's the wording of paragraph 22 of Sir James's skeleton. The true weight will not be given to the public interests against disclosure. But tellingly, I say that introduces a non-statutory concept of the public interests against disclosure. That's not to be found anywhere in FOIA. That was the distinguishing feature, as Mr Knight will come on to, with the directive in Ofcom. But that overarching purpose, the public interest against disclosure, just isn't there in FOIA. That's not the words. The words exhort you to focus on the public interest in maintaining the exemption. The department says, well, the reason Parliament didn't use that phrase, public interest against disclosure, is because the public interests in disclosure are set out in the exemptions in the Act. That's the counter argument. Disclosure is not at large, as Sir James put it. Well, in response to that, the Environmental Information Directive uses a similar generic phrase, the interest served by the refusal. But nobody suggests under that regime that one can therefore import reasons for refusal that are not to be found in the specific exceptions under EIR. So it's a straw man, effectively. It's perfectly clear from the overall structure of FOIA, with its many and carefully defined exemptions, that it is those exemptions that you need to be applied. So this is all an argument about why Parliament didn't use a more generic phrase in section 2.2, which would have made it clear that the interpretation for which the department is contending is the correct one. As we say, if Parliament had intended that one weighs the overall public interest in disclosure, they would have said so.
Against disclosure.
Against disclosure.
Yeah.
They would have said so. So James's answer to that is, no, they had to focus it on the exemptions because the disclosure is not at large. But in fact, that's no answer, because as under EIR, the existence of a more general category doesn't lead decision makers to think that they can go looking for reasons for refusal that aren't anywhere in the Act. I hope my lords follow me. That sequence. The department's position also belies a deeper mischaracterisation of how the Act operates. It's based on a misconception that public authorities' role is somehow to guard information unless no exemption applies. We have to consider all. It's important to get the true weight to consider all of the exemptions that apply. But that's the wrong starting point. That's to take a starting point of don't disclose unless you have to. Whereas the correct approach is the opposite. Disclose unless there is a compelling reason not to disclose. That's the true structure of FOIA.
But isn't it? If you're right, then let's go to section 35(1) for an example. I imagine this is quite a common section, commonly relied on section. So the department has to consider, does the public, supposing that all of 1A, B, C and D are all in play, which they might often be, you say that the department has to consider, does the public interest in maintaining the exemption because a piece of information related to the formulation or development of government policy outweigh the public interest in disclosing the information. Then separately, does the public interest in maintaining the confidentiality of ministerial communications outweigh it? And then separately, the Attorney General or Solicitor General was asked for advice, no doubt drafted by Sir James, but there you are. And that has to be considered separately. And then finally, the involvement of the Minister's private office has to be considered again separately.
Yes.
That seems quite a laborious exercise.
Well, it will be a rare case where those 4 exemptions are all engaged because they are various in nature. C seems is particularly distinct. Ministerial private office is a different matter from government policy. Ministerial communications, they're distinct. And one has to ask oneself, why has Parliament distinguished them in this way? Why has Parliament come to these very specific, much more specific, by the way, than under EIR, these very specific categories of exemption? Now,
if you look at A and B, the formulation of government policy and ministerial communications, it may only be A because it may be civil servants communicating at a very early stage. It may be one Secretary of State to another, the Chief Secretary of State to the Treasury. So you'll have the fact that it's what should we put in the budget, government policy, with a leak to a newspaper saying the Chief Secretary says we should reduce tax by 10p in the pound or something. And then it's a combination of the nature of the material, is what is said against you, together with the high-level source from which that thought is emanating. And you might live with a leak about tax. You might live with a leak about something from the Chief Secretary saying, I think we should reorganise ministerial cars. But if it's a leak from the Chief Secretary of the Treasury about the budget later in the month, the two together, they're saying, might be more problematic.
but what my Lord's analysis identifies is that there are distinct public interests underlying the 2 different sections. One is about the safe space for policy formulation, and one is about the Convention about Ministerial Communications, and those are related but distinct interests, and that is why Parliament has chosen to split them out into different exemptions, separated by an or,
Yes.
thereby creating those as distinct bases in the structure of the section for holding that information is exempt.
Well, the all surely denotes that any one of them by itself might be sufficient.
Well, we say needs to be sufficient
How
when
would
read back into the test in section 2.
how would subsection 3 work? Or 35(3)?
Yes, well, this is an objection raised in the department skeleton. This concerns the the first of the FOIA rights, the very much the Cinderella of the two, section 11A, the right to be informed that the information is held. We've focused all our attention on 11B and its corresponding 22B, which is the more substantive right
Yeah.
to have the information communicated. But in every case, each exemption also contains a test for whether the section 11A duty is disapplied. Do you even need to tell the requester that you hold the information? And in practice, it's very largely applied in national security cases. Not exclusively, but largely. But nonetheless, there is for each substantive exemption an equivalent test for whether 11A is disapplied. Now, that wording that's used in section 35(3) refers, I accept, compendiously to each of the exemptions in 1A to D. But it is clearly in my submission to be understood as referring to any one of them. And the reasons I say that is clear. Firstly, if one looks at the sections that surround it, subsection 2 and subsection 4, they conversely give you specific guidance about the application of individual subsections, subsections. So 35(2)A is concerned with how you apply 35(1)A only. 35(2)B is concerned with how you apply 35(1)B only. And it directs you to treat those in a different way.
Yeah.
Ditto 35(4),
Yeah.
which has something to say specifically, again, about 1A only. So section 35 is a mix, I accept, of treating those exemptions individually, subsection 2 and subsection 4, and compendiously subsection 3. But that compendious treatment must be a reference to whichever of those subsections is engaged. The other reason I say that, note the language of 35(3) and then turn to 37 subsection 2.
Before we do that, we've got to bear in mind 2(1) as well, which is the one that deals with the duty to confirm. And that says, again, either the provision confers absolute exemption or in all the circumstances of the case, the public interest in maintaining the exclusion of the duty to confirm or deny.
Yeah.
And is that just by reference to a provision or the provisions?
The provision conferring the exclusion.
The provision conferring the exclusion. The specific provision.
Yes.
Okay, you were taking us to 37(2).
37(2). That is on page 41 because section 36 is so long.
Got it.
That's the same text,
Yes.
and it's doing the same work in relation to each of the subsections of 37(1),
Yeah.
as 35(3) was doing to 35. But of those exemptions set out at 37(1)A to B, the first 3 are absolute, and the second 3 are qualified. You see that in the list of the absolute exemptions in section 2(3). And so clearly that list in 37(1), they can't be treated compendiously. You must be looking at the individual provisions because in respect of some of them you will and some of them you won't be doing a balancing exercise. So that I say is a further pointer that the compendious nature of 35(3) and 37(2) is simply a convenient drafting of the device. It shouldn't lead you to hold that all of those exemptions are in fact to be treated as one exemption.
Right.
Give me a moment, that's taking me rather out of my seat.
Yes, sorry. We'll have a look at your notes and decide where we go next.
Yes. So, my lords, my lady, I was addressing you on the supposed distorting approach the department says would arise from the respondents' opposition to aggregation. And it has, I say, the vice of starting from the position that information needs to be protected if possible. That multiple exemptions need to be claimed if they can be. But of course, public authorities aren't required to apply exemptions at all. Section 78 of the Act says nothing in this Act prevents you from disclosing, affect your powers outside the Act to disclose information. And that's a key issue in the Kennedy case. That simply because court records are absolutely exempt under Section 32 of FOIA, it doesn't mean there's no power to disclose them under common law powers. That's what Kennedy is all about. So you see references to Section 78 in the Kennedy case. But the broader point is it's perfectly permissible to respond to a request under FOIA and simply not invoke any exemptions, even though you might be entitled to. The role of a public authority is not to guard information, not to ensure that the full weight is given to the public interests that Parliament has set out. But they don't have to do that. For example, it frequently happens that information that is available by another means, that's an absolute exemption under Section 21. But often it's more bother for a public authority to invoke that exemption than it is to just provide the information or provide a link to where it can be found. So there are exemptions which are not taken up frequently in practice. So the notion that there is a true weight to the public interest in withholding information that has been set out in the numerous exemptions under the Act and that needs to be respected in all cases, in my submission, is simply the wrong starting point. The next objection, I think I have time to take this one before the adjournment,
Yeah.
is that all the circumstances is intended to be a pointer towards applying multiple exemptions in the Section 2.2 analysis. But in my submission, that's not the meaning and not the natural meaning of the phrase at all. The circumstances here means the factual circumstances of the case. And it's simply and no more an exhortation to a public authority or any subsequent decision maker to look at how the exemptions which Parliament has delineated necessarily in the abstract, the public interests behind those exemptions, how those apply to the particular facts of the case. And that is now absolutely FOIA orthodoxy, that one applies a contents-based approach and one looks at the specific factual matrix and the specific prejudice that would arise both from disclosure, and one looks at this specific public interest, the benefits of disclosure of the specific information in all the circumstances of the case, bearing in mind the factual circumstances. And one doesn't look, for example, at a class-by-class exemption, as had been argued early on in the FOIA case law. So that, in my submission, is what those words are doing, and that is all that they're doing. They are an exhortation to look at the factual circumstances. And I will just give you, my lords and ladies, a series of references to where the other places in the Act where those words are used,
Yes.
where they are plainly simply factual matters. I don't think we need to go through them one by one in view of the time.
Well, give us your best one, or
Yes.
show us your best one, and then give us the other numbers.
Right. Section 11, subsection 2, at paragraph 15 of the authorities bundle. So, section 11 is a particular provision about the requester's entitlement to ask for information in a specific format. You see that in subsection 1. And
Yes.
in 11.2, the authority is required to do that as long as it's reasonably practicable. And then 11.2 gives you some guidance on what that means.
Yes.
May have regard to all the circumstances, including the cost of doing so. So clearly, that's a fairly nitty-gritty, factual
Yes.
reference. And the same is true throughout the Act. The references are section 15, subsection 3. It's all about setting a time limit in the context of the public records procedures. Section 17.6, about refusals of a repeated vexatious requester. You don't have to keep serving them a notice saying you are vexatious, where it would, in all the circumstances, be unreasonable to do so. They're clearly factual circumstances. And then section 22, subsection 1c, this is the first time it occurs in the only time it occurs in a substantive exemption. Information intended for future publication. Part of that test is whether it's reasonable in all the circumstances that the information should be withheld until a future date when it's intended for publication. So again, a very factual inquiry is directed by those words, in all the circumstances. And again, for your note, you see that confirmed in the De Boer and O'Brien case, tab 15 of the authorities, paragraphs 30 to 31. So I say it's no pointer at all in favour of aggregation. It's simply an exhortation to look at the specific facts, and the department's interpretation, giving that phrase as a legal aspect. One of the circumstances is said to be the fact that two exemptions are engaged. But it would only mean that in cases where that was so, and therefore the phrase is given a curious sort of double life, if you like. It has a legal aspect in some cases and not in others. And Sir James now puts forward a more extreme version. He says that even if we're right on that aggregation is impermissible, and that you have considered the exemptions one by one, all the circumstances allows you to add back in the fact that another exemption is engaged. And that very much is an impermissible fourth stage in my submission. That's not the way I understood the point to be put in his skeleton argument, but that was an additional way it was put in your argument. But that must be wrong, I say, because that implies that all the circumstances changes the test. If we're right about the test and it's exemption by exemption.
Yeah, you're saying it's getting by the back door what you don't get by the front, according to Parliament.
Indeed, I'm grateful for that.
See that.
So that's what I have to say about all the circumstances.
Yes.
That takes me to shortly before
To
1 o'clock, and the next
Yeah.
point is a slightly longer one
Well, just tell us what it's going to be. And,
about exemption and whether it means exempt status or provision of Part 2.
I see. Why don't you at least make a start on that?
Yes. Well, the first point I want to make on that is that even if it's right, I say it doesn't change the picture. The simple meaning of exemption, if you accept that section 2.2 requires a sequential consideration of each provision that is engaged, as I was putting to you earlier, then the question of whether the public interest in maintaining exempt status conferred by an individual provision outweighs that in disclosure. That's effectively the same question as whether the public interest in maintaining the application of the provision of Part 2. So the competing meanings of exemption are provision of Part 2 or quality or status of exemption, but that can only be conferred by a provision. So in my submission, this question of what exemption means is something of a red herring, because it only shifts the question about whether it's one at a time or all together. It only shifts that question linguistically slightly to one side. The same question remains as to whether you are talking about the exempt status conferred by a single provision, or exemption there means words within a section within Part 2 of the Freedom of Information Act. So that's my first submission on that question of the meaning of exemption.
You say that
Sense a question coming from.
the concept of exempt status doesn't take Sir James any further, because you say there's a difference between exempt status by virtue of, say, section 35(1)(d) and exempt status generally.
Yes. If you are with me on the part of the analysis that we were discussing earlier, and that you need to take 35(1)(d) on its own, the fact that it confers exemption, and the exemption that it confers is what is being referred to in 2.2b, then the practical difference is not nugatory.
And you would say the same for the interpretation I suggested this morning, the maintaining of the exemption of the information, and you would say the maintaining of the exemption from the information stage by stage, provision by provision.
Indeed, because that is the sequence that you've gone through.
All right, Mr.
Is that
Locke, would
convenient,
that be a convenient moment in which to pause? Can you just remind me, because I didn't write it down properly, what you've got left on your shopping
I
list?
have left the rest of the discussion about exemption,
Yes,
and that'll take me to section 17,
yes.
and then the points about effectively sub-aggregation, just going subsection by subsection,
Yeah,
which really, I'll go back over my notes.
and then Mr.
Covered a lot of that ground,
Knight is
actually.
going to do.
I'll ask Mr. Knight.
Well, I know everyone's really interested in the EIR point, so I'm going to take that.
Right. Yes.
Yeah, I'm going to have a few supplemental submissions on the section 2 points that Mr. Lockley has made.
Yes.
We'll deal briefly with the case law under section 6 of the Interpretation Act, which Sir James raised and said he'd come back on, left to me to develop. Practicability as an aid to interpretation, a point Sir James denied was relevant, and so I need to address. And then ground 3, the EIR point and its relevance or lack thereof.
Right. Thank you very much. Okay, 2 o'clock.